a conference titled Landmark Judgments by African Union Human Rights Bodies is underway at the Future Africa campus at the University of Pretoria in South Africa, marking the 20th anniversary of the African Court on Human and People's Rights. The event is examining key decisions shaping African human rights jurisprudence and their impact on the continent. Hosted by the Centre for Human Rights at the University of Pretoria in partnership with Monash University's Faculty of Law, the conference brings together scholars and practitioners to reflect on rulings from the African Court, the African Commission, and the African Committee of Experts on the Rights and Welfare of the Child. To tell us more, we're now joined on the line by organiser, Professor of International Human Rights Law from the University of Pretoria, Professor Frans Viljoen. Professor Viljoen, a very good evening to you. Welcome. Thanks for joining us.
Good evening, Mpho, and to the listeners, and thank you for the opportunity.
Perhaps let's start here. What does the 20th anniversary of the African Court on Human Rights Peoples represent for the continent's human rights system, and whether or not the court has lived up to the expectations set at its establishment?
Yeah, I think we can take, if you would, one step back. It's actually also 40 years since the African Charter on Human and People's Rights had entered into force. So that is important to note, because in a sense that is the foundational source on which the continental kind of framework of rights protection is based. Now, the African Charter, which is now in place for 40 years, first was supervised or monitored by a body called the African Commission, but that was not a court. And then 20 years ago, the court was put in place. So the court, I think, was supposed to ensure that at the continental level we have a more authoritative source of minimum common standards that would be applicable to all African states. Unfortunately, not all the states have accepted, because it's an optional process, to accept the jurisdiction of this African court. So far, only 34 of our 55 African Union member states have accepted the court's jurisdiction. Fortunately, South Africa is one of them, and being a South African. So that is certainly an important limitation. But in terms of the accomplishments of the court, I think we've seen it really intervene, because it is there also as a form of last resort when individual remedies at the national level fail. The African court is supposed to be like a safety net. And just to give you one example, in a case against Burkina Faso, an investigative journalist that we find in all states had been on a case affecting politicians in high places. He was murdered in cold blood, and subsequently his family tried to bring some form of closure, get the perpetrators to be brought to justice. They pursued all kinds of efforts, but none of those were successful at the domestic level. At the national level, they brought a case to the African court, and the court eventually decided that Burkina Faso in this case was in violation, because it did not use appropriate measures to investigate this case and to bring the perpetrators to justice. So that violation, then after that, the court ordered the state to actually undertake new investigations and to bring the perpetrators to justice and to compensate the family. And over time, Burkina Faso complied. It investigated, it brought perpetrators to justice, and it paid the compensation. So that is a good news story. That's a good example of what the court can achieve. But certainly these are unfortunately relatively infrequent.
Yeah. It's also interesting that you make mention that it's not all the states which have accepted the jurisdiction of the African Court, because one of the long-standing criticisms, I suppose, of continental human rights institutions is that ordinary Africans don't even know that mechanisms like this even exist. Do you think that access to justice at this level has perhaps now remained largely an elite legal conversation, as opposed to something citizens can realistically use? Does it have to do with the acceptance of some of the states when it comes to jurisdiction?
I mean, so certainly some states have just not accepted the court's jurisdiction at all. So for them, the court, for individuals in those states, the court is never even an option. But in those states, individuals can still take a case or a complaint to the African Commission, which I mentioned. So at least there is that, although the African Commission is not a court, but more like the South African Human Rights Commission, something that's quasi half and half a court. It gives some remedies. But you are right that even in states like South Africa, the knowledge, the awareness of the African court is very low. Even if South Africa has a judge sitting on that court, I think very few South Africans would even know that Dumisa Nsebeza, a prominent human rights advocate, is a member of that court. He's one of the 11 judges sitting on this African court. So you are right that that is a major problem. And perhaps our conference tries to make a small contribution. Even among lawyers, Mpho, even among lawyers, there's still a lack of awareness. So yes, we want to see this broadening to become an issue that more Africans would know and be aware of. But our objective perhaps is modest, to make sure that at least among lawyers there is a good, solid understanding, awareness, and a kind of an alertness to the potential use of this African court.
Yeah, and the potential use would be imperative, especially looking at the political climate across the continent at a time when parts of Africa are facing coups, election disputes, restrictions when it comes to media freedom, a lot of crackdown on dissent. Are African human rights bodies becoming more important, or are we looking at a case where they are becoming increasingly powerless?
Certainly, there is a problem with states accepting the jurisdiction, for example, of the court, and even if there are judgments against states, to abide by those judgments. But Mpho, I think it is important that we do not, throw the baby out with the bathwater, so to say, that the fact that there is an African supranational continental court, which at the very least set the record straight. It holds governments accountable, maybe not in practice, but at least it provides a channel, it provides awareness, it provides beacons and yardsticks. So even if a judgment is sometimes not fully implemented by the state, there is this mobilizing of kind of forces, domestic constituencies around the possibility of accessing the court, and at least setting, as I say, the record plain. And it is by an African institution. I think that's important because our states are very quick to also denounce, UN structures and Western imperialists. Yes, and sometimes that there are elements there. But this is the beauty of the African institutions, and why we will just try always to still invest in them and their legitimacy is because they are African institutions, and it makes it much harder for states to just, out of hand dismiss the judgments of such an African institution set up by the states themselves.
Do you think Africa has, in this instance, built enough confidence in its own institutions to police itself effectively? Because there's also still some criticism that African countries rely too heavily on international bodies outside the continent for human rights accountability.
I think that has been a consistent concern. If one even thinks of this African Commission that I mentioned, more human rights work is actually being done by the Commission because all African Union member states have accepted the jurisdiction of this Commission. And the main obligation of states is that they must report on a few yearly basis. They report to this Commission, and their whole human rights record is then being inspected by this Commission, and then the Commission makes recommendations, and those are supposed to be, implemented by the state. Now, this process itself is an African process, but similar processes also exist within the UN. For example, the UN has a Committee on the Rights of the Child. And unfortunately, what we see is African states are more likely to be up to date with their reporting obligations to the UN systems, treaty system structures, if you like, compared to the African Union. And that is, difficult for us to sometimes comprehend, but I think it's also because of a lack of awareness, a lack of understanding. And again, if I may say that our conference tries to just create greater understanding and awareness around the role of the African Union institutions, to see the complementarity to the UN system that is also there.
Professor, before we let you go, I mean, you touch on the Commission making recommendations which should then be implemented by the state. But do you think human rights institutions truly protect citizens if political leaders continue to treat these adverse recommendations or adverse rulings as recommendations as opposed to being obligated, to treating them as obligations?
Yeah, it's not an ideal position, certainly. And it is an eternal paradox, I'd say, because these African Union institutions are created by the states themselves. So they have created institutions that are supposed to hold them accountable. But when these institutions that are supposed to be independent and have members that are independent from the states, when they give judgments or recommendations, then states often are quite reluctant. So they kind of paradoxically undermine the legitimacy of the very structure that they've set up, and that is the kind of a paradox that I think has to be held out and to be brought into the open increasingly, and that has to happen at the national level. So those recommendations are not going to be enforced by states that are often reluctant. It would be having a chance of better enforcement or implementation if there are some NGOs, civil society, church leaders, labor unions that are aware of these recommendations and come together to push and to create greater expectations of implementation on the part of the state. So I think my message would be that as far as possible, we form greater coalitions among civil society organizations, individuals, and we try to see to what extent can this African Union be made more effective. You are right. At the moment, it lacks effectiveness.
Thank you so much. Thank you for speaking to us and giving us a sense of clarity and understanding there. Professor of International Human Rights Law from the University of Pretoria, Professor Frans Viljoen.